Hello everyone, and welcome to today's session of the conference organized by the University of Economics in Prague. My name is Petr Sprinz and I'm local head of restructuring and insolvency practice in Prague. The topics we are going to cover today are preventive measures available in Germany and in the UK, and their recognition taking into account also Brexit. The theme could not be arguably more acute given the recent developments in these countries. And obviously I cannot handle these topics alone, so I'm happy to have two restructuring specialists with me, Regina Rath and Matthew Thorn. Regina is a partner at Norton Rose Fulbright. She's based in Frankfurt and her practice covers all aspects of German and European insolvency law, frequently also involving cross-border elements. Matthew is a partner at Norton Rose Fulbright based in London. He specializes in large cross-border restructuring transactions. So Regina and Matthew, welcome here. So I will ask first Regina, if I can, what are tools available when it comes to restructuring in Germany?
Thank you very much, Peter, for giving me the opportunity to shed some light on the current German situation and the developments that are currently ongoing in Germany. So as you may be aware, under current German law, we do not have a pre-insolvency regime. If the company is in distress under the current situation, you rather have the choice between an out-of-court consensual restructuring, which requires essentially that all the creditors involved agree. And on the other hand, you have the possibility to enter into court-supervised insolvency proceedings. Those court-supervised insolvency proceedings also offer quite some flexibility with the possibility to have a self-administered insolvency proceeding and also to restructure under an insolvency plan with the company to be able to survive actually and continue after the proceedings are lifted. But as I said, under the current regime, we do not have a pre-insolvency restructuring. But since Germany, as all the other EU member states, are obliged to implement the EU directive on preventive restructuring frameworks, also Germany did its homework and drafted a law that intends to implement the directive, and the draft of the Ministry of Justice was released mid of September with a very fast discussion following with like the industry sectors that had the possibility to comment on the draft. And only this week now, the government draft has been published. So it's a very fast track ongoing, and it is intended that the new law will enter into force 1st of January 2021. And I think we will have some opportunity to discuss and touch on the main points of this new draft later on in the course of the session.
Thank you very much, Regina. If I can turn to you, Matt, what are the possibilities in the UK?
Yeah, thanks. And again, thank you, Peter, for giving us the opportunity to speak today. It's good to be able to share the updates in the UK with the conference. So before June of this year, the options that were available in terms of restructuring procedures in the UK, there are sort of three procedures that were commonly used outside of liquidation procedures. So here we're just talking about sort of restructuring tools. There was pre-pack administration, which involves the appointment of an administrator to consummate a sale of business of a company, usually done quite quickly after appointment. That was one option. Another was company voluntary arrangement, which involves an arrangement between a company and its unsecured creditors. And the third was a scheme of arrangement, which I'm sure people will know about, and that is a compromise or arrangement between a company and its creditors or a class of them, enabling a company to put forward a plan to be approved by a majority of its creditors, and that plan would then be binding on a dissenting minority. In June of this year, the UK brought in the most substantial changes to our insolvency regime in in 30 years through the Corporate Insolvency and Governance Act. And those changes have been in the pipeline for quite some time, since 2016 actually. And it's taken the COVID crisis to bring sort of focused legislative attention on updating our insolvency regime and moving it more towards a debtor-focused recovery regime. And that's what the new law does. So the new law implements, it implemented certain temporary measures, but the three permanent changes that it brought in were a new standalone debtor in possession moratorium, what's been called a supercharged scheme of arrangement, which is based on the existing scheme of arrangement, but then adds in a few elements, including a cross-class cram down, and we can come and talk about the detail of that a bit later on. And the third permanent measure was a consequence of insolvency proceedings. So it wasn't a new proceeding in itself. It just provides for a restriction on the exercise of termination rights and supply contracts where a counterparty has gone into insolvency proceedings. So these measures were brought in similar to what it sounds like has been happening in Germany. They were brought in very quickly. So they went from presentation of the bill through to royal assent, through to becoming law, was only about a month, which is very quick for legislation of this substance. And the expectation is that there will need to be adjustments and tweaks. There are certain parts of the legislation that we think could be improved, and the expectation is that that will happen over the coming sort of months, perhaps years, because there are certain delegated powers in there which enable the Secretary of State to make changes to that legislation without having to go through a full process. So that's a very quick run through of the regime and the recent updates to it in the UK.
Well, thank you very much. I must say, 1 month, it's really super fast track procedure, and I really like the name supercharged scheme of arrangement or supercharged scheme. So, so coming back to German novelties, I would perhaps, suggest to talk about the initiation of the process. Who can actually trigger the process, whether it's only up to the debtors or whether also any other stakeholders can trigger the process, and whether there is any perhaps minimum and maximum threshold or minimum and maximum level of distress, perhaps. Can you please comment on that, Regina?
Sure. Yes, so the new law, the draft law, it contains various elements, and I will be happy to give you an overview of who commences the proceedings and what the different elements are. But first of all, just let me lay down the different pieces of this new legislation, because so the new draft act contains, first of all, an amendment also to the existing insolvency laws. So it is not only the implementation of a new regime in accordance with the directive, but also took the opportunity to modernize the existing insolvency laws. And talking about fancy names, I can now add one. So the German name of the new legislation, so the new act that implements the pre-insolvency restructuring framework is called, and I start with the German version, and Matthew can then repeat, please. Unternehmensstabilisierungs- und Restrukturierungsgesetz. So the abbreviation is STAROG, and I think it's better to use STAROG going further, because otherwise we're running out of time. So the STAROG contains, so to speak, various instruments, and it is for the debtor company to decide which of the instruments it wants to use. So the trigger event, or the requirement for a company to make use of those instruments, is a situation of threatening illiquidity. So the company must not yet be in a situation of actual illiquidity or over-indebtedness, because those are the trigger events for a duty to file for insolvency. But the proceedings under the STAROG start earlier in the situation of threatening illiquidity. It's important to note that threatening illiquidity also allows a company to enter into insolvency proceedings, but that's just an option and not mandatory. So if it's threatening illiquidity, the company essentially has the choice whether to go and try a solution under the STAROC, under the new tools, or to use the existing insolvency regime. So looking at the toolbox under the new law, the company starts, so it's the management of the company that can start the process. It's not a process that can be started by creditors. So the debtor files an application to the court, and in fact the law also, the draft implements a new type of court, which is called restructuring court. So the company files an application and notifies the court of a restructuring event or the intention to restructure. And once this notice has been filed, the restructuring matter is pending at the restructuring court. And following that notice, again, the company has various options. Either it can continue to negotiate with the creditors and also submit a restructuring plan, approve and vote on the plan without any further court involvement, or the company can decide to use additional help from the court. So for instance, the debtor can apply that the voting will be made before the court. The debtor can apply that the plan, once it is voted upon, it is confirmed by the court. Also, the company can apply that the court orders a moratorium, or it is possible to apply that the court terminates certain agreements. So it's a variety of measures that are optional. They can be combined. And so it offers a lot of flexibility. And well, I think the idea is that it's really the company that structures the concept. And whenever the help of the court is needed, the company can actually make use of that help.
Right, right. The company should know the best and then structure it accordingly. Just perhaps, just one quick follow-up question. In case the STAROC process fails, is there any requirement to initiate insolvency proceedings, or is it still up to the company to decide whether there is already insolvency or whether there is still only impending insolvency, so they can wait?
So if during the process, so also as long as the restructuring measure under the STAROC has not failed, but if an event occurs that that an insolvency event is triggered, then this needs to be notified to the restructuring court. But that doesn't prevent the company from continuing under this STAROC procedure or the procedures. Right. But right. If the restructuring under the STAROC fails, then obviously the company will be in a situation where it might face at least over-indebtedness or also actual illiquidity, and then the filing for insolvency will be mandatory. But even then, as I said, German insolvency law also, is quite flexible, and also this would not necessarily lead to a liquidation of the company, but the company might as well restructure under the tools that are available under the insolvency regime.
Mm-hmm. Mm-hmm. Thank you, Regina. And Matt, how it actually works under the new breakthrough legislation when it comes to the supercharge scheme? Are there any possibilities of other stakeholders to initiate a process, and what are the requirements in order to trigger the whole process?
Yes, it is possible for for creditors to put forward a restructuring plan, but that's unlikely. It's a debtor-controlled, debtor-in-possession process. Mm-hmm. It could also be put forward by an administrator or a liquidator, if those were if an administrator or liquidator had been appointed to the company. And the new process does not include a moratorium of itself. So the debtor may want to appoint an administrator to take the benefit of the moratorium that comes with administration, or the company could look to file for the standalone moratorium that comes with that is a sort of standalone that can be combined with the restructuring plan. But there isn't in the restructuring plan itself any sort of moratorium. But it's usually an application to court by the debtor to commence the proceeding, and it will be for the debtor and its creditors, or the majority of creditors that it needs to get the plan across the line, that will negotiate the terms of that arrangement before the application to court. And it will also be for the debtor to decide how they want to constitute classes and divide the creditors into classes by reference to their rights. So it's really a debtor-led process, but up to the point at which the application to court is made, there's obviously the negotiation of the terms of the arrangement that happen between the debtor and its creditors, because it needs to get over the statutory thresholds. But the tool itself, as in Germany, is very flexible. So as long as there is a give and a take, as long as there is some sort of arrangement or compromise between a debtor and its creditors, then it's up to the debtor and the majority as to the deal that they strike. It can't be used to strip rights, and it can't affect, subject to certain exceptions, sort of proprietary rights of creditors. But there is a good degree of flexibility there in terms of what the debtor can put forward.
Thank you, Matt. That's really interesting. And Regina, you mentioned that there are new restructuring courts to be constituted, and the involvement of the court personnel might be perhaps limited, as far as I understand. Is there any possibility to appeal against the court decisions, and is the whole process to be published or in public, or somehow kept in secret?
So to your first question, the courts, the court decisions, they can be appealed by way of an immediate appeal with a 2 weeks deadline. And in particular, this is relevant with regard to the decision of the court to approve a restructuring plan, because the plan, for the voting on the plan, the creditors will divide it into groups. And the restructuring plan does not necessarily need to include all creditors, but it can only just apply to certain creditors, which the company wants to actually restructure. And primarily, it's like mainly focused on financial restructurings. So the creditors will have the possibility to vote, and the majority that is required is 75% of value of claims. So first of all, as a creditor who does not approve the plan, he might be, just part of the group that managed to achieve 75%, and then he is actually, has to live with it unless he files an appeal, and then the court will lift that restructuring plan again. Or what is also possible under this new regime is a cross-class cram-down. So even if a creditor group, an entire group, did not approve it, the missing approval can be replaced. So it is important to have some sort of legal remedy for the creditors affected. So that exists. The second question was with regard to the publicity of the procedure. So that's also one of the key differentiators. German insolvency proceedings are public, so the decisions of the court are published, not the entirety of the court documentation or the files. They are not publicly available. They are only accessible for creditors, but the pure court orders, they can be accessed publicly. For the new restructuring tools, it is again a decision of the debtor whether he wants to have the publicity or not. So if he files an application that the decisions are published, then this will be the case, but it's really just an option. It's not mandatory.
Well, interesting indeed. And Matt, coming to the supercharge scheme, to what extent are courts actually involved? Is it that you actually submit the whole plan and you just get it approved, or is there any sort of possible intervention from the court prior to that?
Yeah, so there are two stages in which a court is involved in the restructuring plan. Initially, when the first application is made, the court will consider the composition of classes that's been proposed by the company, and if it agrees with that composition, then it will make an order that the meetings be convened, and then the company will send all the information out to the creditors to enable them to vote on the proposal that's going to be presented at the meetings. But practically what happens is, even before that first application, the company will want to enter into lock-up agreements with the majority of the creditors, so they know that by the time they go into the procedure that they have the support of the requisite majorities, so they're over the line. So companies will go into that on whatever you want to call it, a sort of pre-packed, pre-negotiated basis. But that may not always be the case. And then at the second stage, the court, once the meetings have been held of each of the classes and the statutory majorities have been passed, or if the statutory majorities in one class are not passed, then the company will need to look to use the cross-class cram down. And we've got the same majorities as in Germany, so it's 75% by value of creditors in each class that are voting. In the case of the old scheme of arrangement, it is just, you also need a 50% by number, but that's been done away with in the new rules. Mm-hmm. And at the second stage, the court will carry out an analysis as to whether the procedural requirements have been met. So whether creditors were given sufficient information and the meetings were properly held and the votes were properly passed. The court will also consider whether there is anything in perhaps the interests of the different creditors. So if creditors have cross holdings in different classes of the scheme, whether there's anything that could constitute an oppression of the minority. So if a minority has been sort of treated unfairly, or there's been sort of fraud on the minority type issues that have arisen in relation to the composition of classes, so whether those classes have been sort of fairly constituted. The court will also look at whether the scheme is fair, so whether it's one that a reasonable person could approve, but the court won't generally look to the commerciality of the scheme, as long as it's not so outrageous that it's something that no reasonable critic could be expected to accept. Then the court will not look behind the majorities if the support of the creditors is obtained, and the court will also look to whether there are any sort of blots, as they say, or any sort of issues that come up in terms of fairness and equitable, whether the proposal is fair and equitable. So the court does have, and that discretion is wide. But it's not exercised very often where the statutory majorities are obviously met. But the new, as in Germany, we've got the new cross-class cram down element that hasn't been tested to the same degree as what the obviously we don't have the same sort of track record in terms of what the existing schemes has. So that's an area that remains uncertain at the moment. So in order to engage the cross-class cram down, there needs to be at least one approving class of creditor, and then the class that's being crammed down has to be treated better than it would be in the relevant alternative, which is more often than not going to be liquidation. So that would involve the court having to do an analysis as to where the value breaks in the scheme, and what the creditor would get in a liquidation, and whether what's on offer is better than what they would get in a liquidation. And obviously there will be expert evidence that will need to be provided in relation to what a liquidation as to what the liquidation analysis is. Another new element, is the ability of the scheme to disenfranchise, or the plan to disenfranchise creditors that don't have an economic interest in the proposal. So those creditors that are underwater, previously what you needed to do if you wanted to clean off those creditors, those subordinated creditors, is go through a two-stage process of implementing a pre-pack and selling the assets into a new company, and then doing a scheme of arrangement in relation to the remaining debt of that new company. But now, with the ability to not take into account the votes of any class that doesn't have an economic interest, that means that you can retain the existing corporate entity, which is helpful because it enables a company to retain its existing licenses and authorities and contracts and things like that. So those are the two new elements to the supercharge scheme, which we're looking forward to using. But the Virgin Atlantic scheme or plan, which recently went through, had a potential for a cross-class cram down, but that wasn't utilized because the class that hadn't already agreed to the proposal did vote in favor by a strong majority. So there wasn't a need to utilize the cross-class cram down, but we're expecting to see it come up soon.
Right, sooner or later there will probably not be always consensus anyway.
Yeah.
Regina, we talk about courts. Is there any special role for insolvency practitioners, insolvency trustees in this process, or is it just simple about negotiations and perhaps just the court?
Well, that's again a very interesting point. Because given this approach that the new law takes, offering various tools and flexibility, also the question whether to involve an external expert in the process is a discretional decision by the company. So it is possible for the company essentially to apply to the court to appoint a so-called restructuring officer, Restrukturierungsbeauftragter. There are certain circumstances where such an appointment is mandatory, but the principle is that it's an option, and this person then will assist and supervise the implementation of the restructuring plan and the negotiations. And as another alternative, it is also possible to apply to the court to appoint a moderator. So that would be a different role, which is more like trying to help to negotiate and find a consensus. So those are the ways for external practitioners to have an official role in the process. But obviously also the company will probably need to have external advisors preparing the restructuring and helping it through the way.
Right, but if I get it correctly, then there is no mandatory role for insolvency trustees then?
No, well, first of all, they would not be called insolvency trustees because this role is really just for insolvency proceedings where you have the insolvency administrator or the custodian, depending on the type of the procedure. And under the STAROG, the pre-insolvency regime, the role would be the restructuring officer, but it's only under certain requirements, it is mandatory. The principle is that it's just an option.
Right. And Matthew, you mentioned that it's actually possible that the whole process is triggered by the administrator, but if there is no administrator involved from the outset, is there any room for the involvement of any court-appointed insolvency practitioners or administrators?
No, there's not in the restructuring plan or the scheme of arrangement. There is in the new moratorium. So there's an insolvency practitioner that will take on the role of monitor, which is just overseeing the moratorium. But in the case of the restructuring plan and the scheme of arrangement, no, there's no specific role for an insolvency practitioner. Obviously, as Regina mentioned, advisors will be appointed on various sides, so debtor, creditor, and financial advisors will need to provide the liquidation analysis that I mentioned earlier, but there's no specific role per se. And it's for the company, as Regina mentioned, to decide which which creditors they would like to include within the plan. So it's not an all-encompassing insolvency procedure where there is an administrator trustee equivalent appointed over all of the assets of the business. It's a surgical procedure that you can pick and choose different classes of debts that you want to deal with as a part of the plan. So it's different from a traditional insolvency procedure in that respect.
Well, you both mentioned the composition of classes, and obviously there will be a lot of interesting details, but just, I will pick up one question that we are dealing with here in the Czech Republic at the Legislative Committee, where we are talking about whether each secured creditor should have a separate group, a separate class. How is it in the UK, perhaps under the existing or pre-existing let's say ordinary scheme and the supercharged scheme? Is it the same? And what are the rules when it comes to secured creditors?
Yeah, so in the recent Virgin Atlantic case, which was the first restructuring plan, the court looked at the existing law and precedent relating to schemes and said that should continue to apply in relation to the new restructuring plan. In the area, there are certain differences, obviously, but in class composition and the analysis as to the sanction, the discretion of the court to sanction the scheme, the court in Virgin Atlantic said that they should look at the existing case law around schemes of arrangement. So it is the same body of case law there. And in terms of how class composition works in the UK, creditors need to be divided by reference to the rights that they hold vis-a-vis the company, and the test has grown up around the concept of the rights of the creditors being not so dissimilar that they're unable to consult together with a view to their common interests. So they need to be able to consult together and their rights to be so similar that they can decide on the plan as a group, as a class. So things like interest rates, currency, sort of covenants, quantity of debt, term, those are things that will not split a class. And what's a usual starting point for class analysis is to look at where the classes would fit in a hypothetical liquidation. So if the company was to go into liquidation the next day, if there were certain creditors that would be paid at a different level from other creditors, for example, an obvious one is secured and unsecured creditors, then their rights are different relative to each other. And then even within the secured creditor class, if the loan to value ratios are so different that they would either get paid out in full or they would only get, say, 20 pence on the pound, then that's likely to be an element that could split the classes. The other side of that analysis is, well, what will the creditors get as a part of the plan? So they also their rights need to be so similar that they can consult together, but also what they're being offered as a part of the plan has to be basically substantially the same. There can be slight differences, and what's become common, for example, is for certain creditors, say there's a group of unsecured creditors who may have various different instruments. If certain of those unsecured creditors form, say in the case of a bondholder group, form an ad hoc group, then they can be paid work fees and certain other sort of limited fees outside of what would be termed the consideration for the plan. Then that's something that has been accepted by the court as permitted and not something that will split the class. But if you start offering different creditors within, say, the one group of bonds, if you start offering them different deals, then that's something that would obviously split the class. So you effectively the creditors need to have the same rights and they need to be treated the same. And that's how you constitute classes.
Right. So that's great that you can draw on the existing case law so that it's not completely new. And Regina, what is the position then of creditors and the constitution of classes in under the newly contemplated Staruk, and is there any perhaps potential of drawing on the existing case law on German current reorganization, where you perhaps might also use classes?
Under the German insolvency regime, we already also have quite detailed rules on how to structure creditors into groups if you want to implement an insolvency plan. So the way that the draft law is built up is in certain ways quite similar to what we already know under the German insolvency code. And also under the Staruk, the concept is that the creditors which have like equal interests have to be grouped in the same group. So for instance, secured creditors should form one creditor group, then creditors with claims which would in an insolvency correspond to regular insolvency claims would build a separate group. Subordinated creditors would be separate group. And if shareholders are also affected, then they would be in a separate group. They can then again be split up into further subgroups if you wish, but that is really then up to the company that drafts the plan. So that's the overall architecture, how the classes are, the creditors are grouped. And again, it's a lot of similarity with what we know under the German insolvency code. Maybe one difference, and which is a very important difference, there are certain claims that cannot be part of a restructuring under a restructuring plan, and therefore also creditors with those claims cannot be included and cannot form a group. And in particular, it's employees. So usually in insolvency restructuring, those employees will build a separate group under the plan, but since they are excluded from a restructuring under the Staruk, they will not be involved.
Perhaps just a quick question to Matt. When it comes to employees' claims, can they be affected, or are they also exempted from the regime of a supercharged scheme?
No, well, there's flexibility in terms of the creditors that can be included, but similar to Germany, the plan is aimed at financial creditors, and it can include trade creditors, but it's predominantly aimed at financial creditors. Right.
Great to hear that, and I think employees will be happy to listen to us then. We also touched upon the issue of the possibility of having some sort of moratorium issued by the court. Regina, are there any requirements that you have to actually meet in order to persuade the court that the moratorium should be issued, or is it, let's say, some sort of automatic regime, at least for the initial phase of the whole process?
It's what the common requirement is, that the company decides that it wants to have this moratorium in place. So the restructuring court will not automatically issue an order for a moratorium, but the requirement is that the company wants this moratorium to assist in the restructuring. Again, as I said, it's an option, not mandatory.
And Matt, how is it in the UK? Can if you then apply, do you need some sort of consensus of creditors in order to persuade a court to issue it?
No, so in the case of a standalone moratorium, that can be obtained by the company filing some simple papers with the court. The initial period is a month, and that can be extended with the consent of creditors. And it can be extended again if you don't get the consent of the creditors with the consent of the court. But that the new moratorium doesn't apply to financial service providers and financial contracts, so loans, finance leases, and the like. So it won't apply to the financial debts of the company, which means that the standalone moratorium is predominantly aimed at SMEs, trade creditors. So save for the moratorium that's available in administration, which captures all creditors of the company, there isn't a moratorium available as a part of the restructuring plan. So if you needed a moratorium, then you would need to use the administration moratorium.
So in other words, you cannot use the standalone moratorium to prevent, for instance, banks from enforcing their security interest.
Yeah, that's right.
And sorry.
I was going to say, so that that then means that if a plan is proposed that secured creditors don't like, or even that creditors don't, unsecured creditors don't like, if they have an ability to enforce, then they will be able to enforce before the plan even really gets off the ground. So that's why to date, schemes of arrangement have really been limited to, say, a syndicated loan where you have 10 lenders and one lender is holding out, because that one lender doesn't have enforcement options because it's usually a majority lender decision, but you can't get the all lender consent required to do a debt for equity swap. So that's where schemes have been predominantly used to date. And with the new plan, there's also an ability we don't have an absolute priority rule in our cross-class cram down. So there is a potential for the unsecured creditor class to cram up on the secured creditor class, which is interesting. So where the secured creditor class didn't agree to the plan, but the unsecured creditor class did, strictly that's able to be, that plan would be able to be sanctioned by the court. But the expectation is that the secured creditors are not just going to sit there and let that happen. So if that was proposed, then they would take enforcement action under their security. Yeah, there are those, there's that level of protection that's available to creditors in terms of actually being able to take action if you don't agree with the plan, which again is it's different from Chapter 11 in the US, which obviously has a very strong worldwide stay. So when we're advising clients in terms of international options, then that's a debate, as if you do need a stay or you feel you will, then you need to look to the US because you're not able to get the stay as a part of the scheme or plan in the UK.
Yeah, perhaps if you need a really overarching stay, you can go also to the Czech Republic, but probably this will not be the case. Regina, is the stay actually also so limited in Germany as it seems to be in the UK?
No, there are only a few exceptions which kind of security or collateral it does not apply to, and so it does not apply to financial collateral, and also netting arrangements are excluded. So those are the exceptions, and the moratorium is only, let's say, limited in time, because the law provides for a certain maximum period, which is essentially 3 months. It can be extended to 4 months under certain circumstances, and the absolute maximum is 8 months. So there are certain restrictions, but not as much in terms of what is excluded as collateral, but only the overall duration.
Right. Well, so we touch upon which jurisdiction is perhaps more attractive, whether UK, Czech Republic, or Germany. So Regina, could you please then comment on what are the possibilities of the usage of such Stáruk process by foreign debtors, whether there are any requirements in order to avail of it from the perspective of international jurisdiction?
The restructuring court needs to accept international jurisdiction, and there is quite a high requirement, because the basic principle is that the restructuring court has jurisdiction if the company has its registered seat at the location of the restructuring court, or at least it has the center of its main economic activities at the location of the restructuring court. So I think the UK is a bit more flexible in that regard, and sometimes requires only some sort of sufficient connection that would not be sufficient for the German restructuring court to accept international jurisdiction.
So Matt, how difficult is it actually to get to the UK and use the supercharged scheme?
Yeah, as Regina mentioned, the threshold is relatively low for foreign companies that want to come to the UK to use the plan. They need to have a sufficient connection to the UK, and that has been held to be satisfied where there is debt governed by English law that's subject to the scheme. So if you've got an English law facility agreement or notes. And the popularity of schemes for foreign companies has grown over the last few years. And what's been quite common as well is the change of governing law even for foreign companies to provide that jurisdictional hook into the UK. And what we've also seen recently is the incorporation of UK subsidiaries that will then voluntarily undertake the obligations of another group company to bring in the English jurisdiction to play. The court, when it looks at forum, because this is forum shopping, and the UK, the English courts distinguish between good forum shopping and bad forum shopping. So they will do an analysis as to whether what is available in the UK is available in the debtor's home jurisdiction, and whether there are good reasons for the debtor to have come to the UK to consummate its restructuring. That would be considered good forum shopping if it's for the benefit of the company and its creditors. Bad forum shopping is if the debtor is simply coming to the UK to try and evade the debts of its creditors in its home jurisdiction. That's something that the court would be less likely to accept in terms of the jurisdictional test. But yes, the threshold is lower. What the court will also need to consider, and this touches on Brexit, they need to consider the impact of the recast Brussels regulation, and whether where there are European creditors, whether the Brussels regulation would restrict their ability to take jurisdiction, because what a scheme effectively amounts to is the debtor suing creditors in England. And the Brussels regulation obviously provides that counterparties should be sued in their jurisdiction of domicile, but there are certain exceptions in the Brussels regulation which would apply to exclude that starting position, including where there's at least one creditor that is domiciled in the UK that would enable you to sue collectively creditors in the one jurisdiction, or where there's an exclusive jurisdiction clause. There are difficulties. Well, the English court hasn't stated a firm position as to whether the Brussels regulation actually applies to schemes of arrangement. So when they're looking at that analysis, they assume that the Brussels regulation does apply, but then they look to whether exceptions in the cases would mean that they still have jurisdiction. And to date, all the schemes that have gone through have been able to satisfy those one of those sort of two main exclusions. But obviously, with the transition period, the Brexit transition period at the end of the year, that analysis won't need to be done anymore. So the Brussels regulation will fall away, and the UK court won't have that additional sort of barrier to jurisdiction. The flip side of that is that the UK court, the English court, when it is taking jurisdiction, needs to be sure that the scheme will be given effect, or needs to be comfortable that it's likely the scheme will be given effect in relevant foreign jurisdictions. So how that happens in practice is the debtor will adduce expert evidence that says a scheme is going to be given effect, say in the US under Chapter 15, or where a debtor has assets in, say, Germany. then the debtor would adduce expert evidence from a German, sort of usually it's a retired insolvency judge or a professor, saying that the scheme is likely to be given substantial effect in Germany. And what the opinion of European countries to date has said is that because a scheme results in a court order, that it's likely to be given effect under the Brussels regulation, and that's been sufficient for the court to get itself comfortable that it can take jurisdiction in England, because it knows that that scheme is likely to be recognised elsewhere in Europe. But now that's not so clear, obviously, with Brussels falling away.
Yeah, so yeah, hopefully, you know, once I will become a retired attorney, I will be perhaps hopefully instructed by any of the advisors to give an opinion about the Czech law. But Regina, how do you actually see the potential recognition of supercharged scheme in Germany? Because obviously German economy is huge. It has been doing well for a long time, and definitely there might be some creditors affected by the supercharged scheme. So perhaps they might not be happy with the final outcome. Do you think there might be some difficulties with the recognition of the supercharged scheme, and how do you actually see the experience with the pre-existing scheme of arrangement?
Yeah, as Matt already said, there has been quite a few examples also involving German companies that wanted to restructure under a scheme in the UK. And so we have some case law on recognition of solvent schemes in Germany. And the position until now was that, well, the German court first always discussed, does that fall under the European insolvency regulation? But since it is not mentioned under Annex A of the insolvency regulation, that was not the appropriate legal framework for recognition. So then the court discussed the Brussels regulation, and that was essentially then the applicable regime. So solvent schemes were considered as enforceable in Germany based on the Brussels regulation. But since this will no longer apply after, you know, the UK finally is leaving the European Union, we will need to look at the general rules that apply with respect to the recognition of foreign judgments in Germany. So we do no longer have the privilege of automatic recognition as we had under the EU legislation. And so the standard rule under German procedural law is section 328 of the German Code of Civil Procedure. And so recognition of a foreign judgment needs to meet certain requirements. And so the recognition will not be given if the court that handed down the decision did not have jurisdiction according to German law. So this is quite a high standard. And also, well, in addition to other requirements, the foreign judgment will not be recognized if there is no reciprocity. So as Matt said, maybe it is easier in the UK not to longer need to take into consideration any requirements under the Brussels regulation. So maybe it's easier in the first place to get the scheme, but it will be much more difficult, in my view, to get it recognized in Germany.
Mm-hmm. Yeah, it's well, definitely sooner or later we will have to handle first cases then coming from the UK. And Matt, if you perhaps, you know, we heard about Staruk. Do you have any preliminary opinion to what extent it would be actually recognized in the UK?
Yeah, so with the insolvency regulation and the Brussels regulation falling away, we have enacted the UNCITRAL model law on cross-border insolvency in domestic legislation, which is our cross-border insolvency regulations. We've made some slight adjustments to it, but it incorporates the model law. So that means where a foreign proceeding satisfies the definition of foreign proceeding, it will get, where it's a foreign main proceeding, it will get automatic there needs to be an application to court, but then the court will grant immediate, or is required to grant immediate relief. Whereas if we're dealing with a foreign non-main proceeding, then the court has discretion to grant relief that would be available, a certain specific relief, or relief that would be available to an English office holder. In terms of whether Starhook would be given recognition in England, the question initially is whether that would constitute a foreign proceeding for the purpose of the UNCITRAL model law. So that requires the proceeding to be a collective judicial or administrative proceeding pursuant to a law related to insolvency, in which proceeding the assets or affairs of the debtor are subject to the control of a foreign court for the purpose of reorganization or liquidation. I just read the definition because it's quite an important definition, and there are some interesting points in there as to whether the German procedure would satisfy those requirements. So first of all, well, Regina, do you want to pick up on your side? I think whether I think there were a few points that we had been discussing in terms of whether that would satisfy the requirements. So I think the first one was whether it was collective proceedings, and then whether it was pursuant to a law related to insolvency, and then to what degree the German court exercised control or supervision over the proceedings.
Yes, I mean, the question of collective proceedings, as I mentioned, the restructuring plan under the Starhook does not require all creditors to be involved. So the debtor may just choose certain creditor groups, and so it's maybe not necessarily a collective proceeding, although certain creditors will be involved. And then is it an insolvency proceeding? It starts earlier than the actual insolvency proceedings, because it's the threshold is threatening illiquidity and not actual illiquidity. It's quite close, of course, but it is not as such an insolvency procedure. So those are the points where, you know, one might argue.
Yeah, and I think obviously it will be a matter of English law as to whether we're willing to accept jurisdiction. And we can take, when, for example, when looking at whether the proceedings are collective or not, the English position is that it doesn't necessarily need to be all-encompassing insolvency procedures, like, say, would be the case in a liquidation. It is possible that reference to collective can include more limited classes of creditors, like Regina described, but then we would need to look at the purpose of the procedure and whether it was related to reorganization or liquidation, and it would fall into the reorganization category in this case. But I would say that under, for example, in the US, under Chapter 15, which is their enactment of the model law, schemes of arrangement are commonly recognized under that enactment, which includes the same tests, so includes the same requirement for the proceedings to be collective. So in the US, it doesn't mean that the proceedings need to encompass all creditors, so they've been willing to take that interpretation of the model law, and so that would be the position that we would seek to state would apply in the UK to the German to the Starhook proceedings.
You also mentioned that you need to have a court decision or some type of court involvement, and then again it will depend on which instruments the company chooses. So I would assume that if the intention of the company is to also have, you know, international reach, the route would rather be to get the court involved to, you know, meet this requirement as well.
Yeah, and the in England, the test for court supervision doesn't need to be, it can be direct or indirect. So the threshold there is relatively low, but there does need to be an element. So I think to the extent that the company sought, for example, the court sanction of the plan, or went to the court to get approval for a cross-class cram down, or used the court's approval to gain a moratorium, or any of those sorts of options. That's the sort of court involvement that should satisfy the test under the English legislation.
Well, that's really interesting. You know, the more we dig into details, the more questions I actually have in mind. And since we are also limited in time, then perhaps, you know, I will just ask you one final question. And it's what do you find the most challenging in respect of new tools available? Because when we are discussing in Czech Republic what might be the biggest challenges, obviously, since I'm also involved in the legislative committee, the law will be as precise as possible, but we have also some other possible impediments, such as the education of the respective stakeholders and the whole structure of courts, let's say the culture, the context, the previous experience that we can draw upon. So, Regina, what do you think would be the most challenging to the success of STARUG?
I think there are challenges, of course, but I think the advantages are much higher because, first of all, this is a piece of legislation that has really been awaited for a long time, to have the possibility to restructure pre-insolvency. And as I said, we've looked to the UK and have used schemes because that didn't exist in Germany. And we are just waiting for it to be implemented to then finally have the possibility to have also those tools available. So in that sense, the challenge that I would see is, of course, that it is a new piece of legislation and we need to learn how to best apply it. There are elements that we know from insolvency proceedings, so we have a certain experience with part of it, but of course there are new tools and those need to be filled with life. And actually we need to see how this then develops. And I think it will be extremely difficult, if not impossible, for a company to use those instruments without external assistance, because it is a complex system. You need to know what suits the purpose of your restructuring best. And so maybe that's the biggest challenge, so to speak, to be effective in identifying the right instrument. And this is something where the company will need to depend on lawyers and other experts, I think.
Thank you very much, Regina. And Matt, what are the biggest challenges to see in the UK?
Yeah. If you'll permit me a pitch from the UK, I think we have the benefit of the track record and the certainty of English law and the previous cases around schemes to give the restructuring plan that level of certainty. Also the sort of experienced judiciary. And we've already got precedent in terms of foreign recognition of schemes in, say, the US and other countries. That brings me then to where the challenge is, and that will be in the European context, how we deal with cross-border recognition after Brexit, because I mean there are a number of issues related to Brexit. That we don't have time to go into, but the Brussels regulation has been helpful for the UK to provide for automatic recognition of schemes throughout Europe. But what this now means is, as Regina mentioned, that it's going to make things a bit more difficult. The expectation is that it's a matter, obviously, for each of the other member states' domestic laws as to how the schemes and the restructuring plans will be recognised going forward. And our expectation is that they should or there are regimes in place that will allow for recognition. It's just not going to be as easy, and it might be more time consuming and a little bit more costly. So I think that's where the challenge will lie from us, is trying to get a good recognition regime in place following Brexit.
Well, Regina, Matthew, many thanks to both of you. We've heard quite a lot about this new Staruk process that is to be enacted in Germany, and also about the supercharge scheme. We can actually learn some lessons. So, for instance, if I see the possibility to change the governing law, I would become more suspicious when it comes to the choice of English law. So perhaps, somebody will be thinking about using the supercharge scheme. And I know what is good and bad shopping and some other information. There is definitely, a lot to talk about in the upcoming year to come. So hopefully, we will meet in person in Prague next year to discuss whether we were right about the challenges and what are the real opportunities then. So let me thank you once again for taking part in the discussion. I'm really grateful for having both of you here, and let me wish you stay safe and have a good day.
Thank you,
Thank you.
Peter.
Thanks very much.